Hello everyone. Now we have reached to part 2 of our constitution, that is citizenship. And in the meanwhile, I have realized that maybe I'm speaking or reading it way too fast. So, being a mathematics student, it's fairly normal for me to criticize every step and to make it better for you guys and for me too. So, now we read a little bit slowly so that we can get the content in our head too. So, Article 5. Uh, Let me begin reading. And these are the perfectly best notes for everyone who is trying to understand Constitution from the beginning and from the basics. So, yes, Article 5, Part 2, Citizenship, and Article 5, Citizenship at the commencement of the Constitution. At the commencement of this Constitution, every person who has his domicile in the territory of India and A. who was born in the territory of India, or either of whose parents was born in the territory of India, or who has been ordinarily resident in the territory of India for not less than 5 years immediately preceding such commencement, shall be a citizen of India. Um, we can get from this article that a citizen of a country is a person who enjoys all civil and political rights. Citizenship carries with it certain advantages conferred by the Constitution. For example, right to vote, freedom of speech and expression, right not to be discriminated on the grounds of religion, race, caste, sex, or birth, place of birth, etc. Article 5 talks about citizenship by domicile. A person is entitled to citizenship by domicile if he fulfills the following two conditions. Firstly, a person who had his domicile in India at the commencement of the Constitution. Secondly, such person must fulfill any of the three conditions, namely, he was born in India, or either of his parents were born in India. That was second condition. And third condition is he has been ordinarily resident of India for 5 years immediately before the commencement of the Constitution. The three conditions I will read again for you. Firstly, he was born in India. Secondly, either of his parents were born in India, or third condition, he has been ordinarily resident of India for 5 years immediately before the commencement of the Constitution. The Constitution of India recognizes single citizenship, that is, there was only citizenship of India and not the state citizenship. Domicile, although the term domicile is not defined in the Constitution, but the court has given clarification of this term in different case laws. A person is said to be domicile of a country in which he has or is deemed by law to have his permanent house. In Central Bank of India versus Ram Narayan, AIN 1955, the Supreme Court said that domicile is not only residence, but it is residence coupled with intention to live indefinitely at that place. In Muhammad Raza Davastani versus State of Bombay, AIN 1966, the Supreme Court said that domicile means a permanent home or place where a person resides with the intention of remaining there for an indefinite period. Now, Article 6 rights of citizenship of certain persons who have migrated to India from Pakistan, notwithstanding anything in Article 5. Notwithstanding anything in Article 5, person who has migrated to the territory of India from the territory now included in Pakistan shall be deemed to be a citizen of India at the commencement of the Constitution if A. He or either of his parents or any of his grandparents was born in India as defined in the Government of India Act 1935 as originally enacted, and B. Firstly, in the case where such person has so migrated before the 19th day of July 1948, he has been ordinarily resident in the territory of India since the date of his migration, or secondly, in the case where such person has so migrated on or after the 19th day of July 1948, he has been registered as a citizen of India by an officer appointed in that behalf by the government of the Dominion of India on an application made by him therefore to such officer before the commencement of this constitution in the form and manner prescribed by the government, provided that no person shall be registered unless he has been resident in his territory in the territory of India for at least 6 months immediately preceding the date of his application. Now we will understand under this article, persons who have migrated from Pakistan to India may be classified into two categories for the purpose of granting citizenship to them. That is, those who came to India before 19th July 1948 and those who came on or after 19th July 1948. This article provides that a person who has migrated to India from Pakistan shall be deemed to be a citizen of India at the commencement of the Constitution, provided such person has been resident in territory of India for at least 6 months immediately preceding the date of his application for registration. Article 7 Rights of citizenship of certain migrants to Pakistan. Notwithstanding anything Article 5 and 6, a person who has, after the first day of March 1947, migrated from the territory of India to the territory now included in Pakistan, shall not be deemed to be a citizen of India, provided that nothing in this article shall apply to a person who, after having so migrated to the territory now included in Pakistan, has returned to the territory of India under a permit for resettlement or permanent return issued by or under the authority of any law, and every such person shall, for the purposes of Clause B and of Article 6, be deemed to have migrated to the territory of India after the 19th day of July 1948. Article 7 stipulates that those persons who migrated to Pakistan after 1st March 1947 shall not be deemed to be citizens of India, but those who return to India under a permit for resettlement or permanent return issued by authority of law and had complied with the conditions of Article 6, subsection 6, shall be deemed to be Indian citizens and deemed to have migrated to India after 19 July 1948. Article 8 Rights of citizenship of certain persons of India origin residing outside India. Notwithstanding anything in Article 5, any person who or either of whose parents or any of whose grandparents was born in India as defined in the Government of India Act 1935 as originally enacted and who is ordinarily residing in any country outside India as so defined shall be deemed to be a citizen of India if he has been registered as a citizen of India by the diplomatic or consular representative of India in the country where he is for the time being residing on an application made by him therefore to such diplomatic or consular representative whether before or after the commencement of this constitution in the form and manner prescribed by the government of the Dominion of India or the government of India. Now, this provision has a purpose of granting citizenship to Indians living in foreign countries at the commencement of the Constitution. A person who or any of whose parents or grandparents was born in India as defined in Government of India in 1935 as originally enacted, but who is ordinarily residing in any country outside India, whether before or after commencement of the Constitution, shall be deemed to be an Indian citizen if he is registered as such by making an application in prescribed form and manner to the consular or diplomatic representative of India in the country of his residence. Article 9 here means, Article 9 states that persons voluntarily or acquiring citizenship of a foreign state not to be citizens. No person shall be a citizen of India by virtue of Article 5 or be deemed to be a citizen of India by virtue of Article 6 or Article 8 if he has voluntarily acquired the citizenship of any foreign state. Article 9 enunciates that if a person has voluntarily acquired the citizenship of any foreign country, then he shall not be a citizen of India. Article 10 Continuance of the rights of citizenship. Every person who is or is deemed to be citizen of India under any of the foregoing provisions of this part shall, subject to the provision of any law that may be made by Parliament, continue to be such citizen. This article states that every person who is deemed to be an Indian citizen is according to the foregoing provisions shall continue to be such citizen subject to the law made by Parliament. Article 11 Parliament to regulate the right of citizenship by law. Nothing in this foregoing provision of this part shall derogate from the power of Parliament to make any provision with respect to the acquisition and termination of citizenship and all other matters relating to citizenship. This article lays down that the Parliament has absolute power with respect to all the matters relating to citizenship. By exercising the power under this article, or the Parliament has enacted Citizenship Act 1955. This act lays down the various provisions for the acquisition and termination of citizenship. The Citizenship Act 1955 has been amended by Citizenship Amendment Acts of 1986, 2002, 2003, 2005, and 2015 lately. The latest amendment has happened in 2019, which is called Citizenship Amendment Act 2019. The Citizenship Amendment Act 2019, the Citizenship has amended Citizenship Act 1955 and it liberalized the grant of citizenship for non-Muslim migrants from Pakistan, Bangladesh, and Afghanistan who have entered into Indian territory on or before 31st December 2014. If you get the message, you know where I'm stating it to. The amendment makes migrants belonging to Hindu, Sikh, Buddhist, Parsi, Jain, and Christian religion from Pakistan, Bangladesh, and Afghanistan eligible for citizenship by naturalization if they can establish their residence in India for a period of 5 years instead of existing period of 11 years. According to the third schedule of the Citizenship Act 1955, a person may obtain citizenship of India if he has resided in India for a period of total 11 years in last 14 years and for at least 1 year continuously before making an application for citizenship. Acquisition of citizenship. Citizenship can be acquired through four ways: by birth, by descent, by registration, and by naturalization. These are the four methods to be a citizen of India: by birth, by descent, by registration, by naturalization. Two well known principles for grant of citizenship are jus soli and jus sanguinis. Jus soli means right of soil, birthright, and jus sanguinis means right of blood, citizenship by descent. By just solely, citizenship is granted to all the persons who are born in the territory of India, regardless of nationality of parents. By just sanguinize, citizenship is granted to a person on the basis of nationality of either of or both of his parents, regardless of the place of birth. Termination of citizenship. The citizenship can be terminated by the following ways: by renunciation of citizenship, if a citizen voluntarily acquires the citizenship of another country, and third, the deprivation of citizenship by government of India. These are the three ways which can be used to terminate a citizenship. Firstly, by renunciation, by leaving yourself. Secondly, if a citizen voluntarily acquires its citizenship of another country, deprivation, and thirdly, the deprivation of citizenship by the government of India. Okay. Now we have talked about article um article hmm, Article 5 to Article 11, Part 2, Citizenship. I hope you have got the required information about citizenship in India and the renunciation of it, termination of it. Thank you.